Thank you. All right. What's your name, ma'am?
Arson, Lamson.
And was this the one where the victim was going to call in and he's not here yet? Okay. Let's wait a minute. We gave the victim all the information to call in and he wanted to be heard. So, but we just gave it all to him. So we'll give it a minute and see if he signs in.
In the meantime, Your Honor, I'm the Spanish interpreter. I didn't receive a list for tonight, so I don't know if there are any Spanish speakers tonight.
There are not, and you can be excused. Thank you.
Okay, thank you. Good night.
Good night. You guys have anybody else in the room?
Yes, we do.
Okay, why don't we have Miss Lamson sit down for a minute and then see if the victim calls in and we could do the next person. Thanks.
Put your hand up. Put your arms up. All the way. Put on.
What's your name, sir? Okay. You have 2 criminal trespasses, possession of prescription drugs, and a failure to appear that I'm seeing you on. A criminal trespass. Because I'm going to order you not to go back to any incident locations, and then I know that you're being held for other stuff. So anyway, I'm just going to give you a city public defender. And December 19th at 9. Next court date. Okay, bye. I think we can have Ms. Lamson back yet now. The victim here on the Lamson case.
Hello.
Hello, what's your name, sir?
Hi. My name is Aaron.
Okay, all right, so Ms. Lamson, you are charged with domestic violence, criminal damage. And I'm going to order you not to commit any acts of domestic violence, and I'm going to release you. And you need to come back to Sarita Municipal Court on November 25th at 8:30, or a warrant will issue for your arrest. My understanding, sir, is that you are comfortable with contact and return. Is that correct?
Well, we live in a state of a little bit.
No, but you can just tell me whether or not you want to have contact or return. So I can't hear anything about the case today. So if you're not comfortable with that, I will order no contact now.
However, if you need a site file, if this is not the way you can with the DCS.
Today, you can talk to the Sarita.
I understand.
Okay. So.
Okay, so now how does this work? Are you the judge?
Court date will be November 25th at 8:30, and you need to come to court at that time, and you can talk to the prosecutor at that time and to the judge. You have a right to be heard. Now, I'm just going to order no acts of domestic violence, ma'am, no alcohol or illegal drugs, and come back to court November 25th at 8:30. Okay?
And no weapons?
No, I didn't see anything that would require that tonight, sir. Thank you.
Okay, what should I do to get picker? Yeah.
Kennedy Noriega.
All right, you're charged with 3 counts of child abuse, domestic violence assault, domestic violence disorderly conduct, and 3 counts of endangering the health or safety, life or health or safety of minors. So I'm going to appoint Peter Gutierrez to represent you on these also. I'm going to hold you on a $1,500 bond, and we'll consolidate all of your cases, and you'll be seen on November 7th at 1:45. And no contact with any of the victims unless it's through unless DCS approves it. And that's it, ma'am. So Pete Gutierrez will be out to talk to you. Hi, counsel. How are you?
Hi, Judge. I'm good. How are you?
Good.
Thank you, Judge. I missed all the judges too. Move down every time someone does.
What's your name, sir?
Hello, good evening. Roberto Enrique.
All right. You are charged with 2nd-degree burglary and possession of a narcotic drug. I am going to appoint the public defender to represent you and order you not to go back to the incident location, no contact with the victims, no alcohol or illegal drugs. I'm going to release you to pretrial services, so you need to report to them and come back to court in Green Valley for your preliminary hearing on November 20th at 1:30, or a warrant issue for your arrest. You understand?
Yes.
All right.
Please start the door.
What's your name, ma'am?
Natasha Park.
All right, you are charged with aggravated driving under the influence and felony criminal damage. And counsel, the state's asking for a $20,000 bond. I know we're a little hampered, all of us, by the fact that there's no background checks that are being run. So did you want to be heard?
Yes, please, Judge.
Yes, Your Honor.
Oh,
Oh, I'm sorry.
I'll let the state go first.
Sorry, Your Honor. I just would like to highlight the fact that it was a 299 on the PBT. There were several admissions, and she was already on misdemeanor DUI probation at the time of this offense. She admitted to crashing, and she admitted to being, quote, jacked up when the police asked her if she'd been drinking alcohol.
Okay. All right. Defense?
thank you, Judge. So I understand the state's position. However, Ms. Horn was previously on probation on 3 separate matters, and she earned misdemeanors on all 3 felony matters, looking at the pretrial services report. That's what it says. We acknowledge she has that misdemeanor DUI case, Your Honor, in city court, I believe. But given that Ms. Horn has lived in Tucson for 11 years, seems to be employed full-time and has a grandma who can assume third-party custody and take her to court, we're asking you to consider giving Ms. Horn one chance on pretrial services. And that's it, Judge.
Okay.
Thank you.
I will note that it was a extreme DUI with an alcohol of 0.20 or more on this last one. I am going to appoint the public defender to represent Ms. Horn. No return to the incident location, no contact with the victims, no driving without a valid license, no alcohol or illegal drugs. I am going to hold her on a $15,000 bond, pretrial services if posted, and the preliminary hearing will be November 12th at 1:30. What's your name, sir?
Jonathan Lara.
All right, you're charged with arson of property and domestic violence, criminal damage. And I'll ask the state, since pretrial services didn't say anything about this pending felony. Is a pending felony a DV?
Yes, Your Honor. It's a similar situation where he had a knife and threatened to kill his wife and crashed his car into her car. The incident date was 8/23/25, and it's pending charges in our office.
Okay. All right. So the state's asking for a $20,000 bond. Defense, would you like to be heard?
Certainly, Judge. I have no information about this pending DB case. I'm hearing about it for the first time from the state. I didn't see anything on the pretrial services report either.
Yeah,
Uh,
I didn't either. That's why I got it off of her recommendation. So I was curious, but
Oh, okay. So, Your Honor, but before the court is this case only, so I'd ask the court not to consider the other matter since it's not issued yet. We would ask the court to consider releasing Mr. Lara to pretrial services supervision, primarily because the victim was contacted, she suffered no injuries, and she surprisingly wants further contact. Mr. Lara is employed full-time. His last conviction is relatively old, from 2014. So, Judge, we are asking for pretrial services, but if Your Honor's not inclined, we ask that the bond be somewhere close to $2,000. Thank you.
I will appoint the public defender, and I know that Ms. Chesney said she wanted contact, but I'm not comfortable with this if there's two alleged incidents is pending. So I'm going to order no contact with Ms. Chesney, no return to her home, work, or school, no firearms, no alcohol or illegal drugs, no acts of domestic violence. And I am going to hold the defendant on a $20,000 bond, pretrial services if posted, and November 12th at 1:30 will be the preliminary hearing. What's your name, ma'am?
Heather Marks.
You are charged with felony criminal damage and the state is asking for $20,000 bond. We don't have any background checks. Does the state have any knowledge of any other prior DUIs?
Your Honor, I don't have any information regarding any prior DUIs. My main concern in this case is the fact that she admitted to consuming alcohol, admitted to falling asleep, and she drove her vehicle into a home, which not only caused significant damage to the garage and the vehicle inside, but to the belongings around it. And the state is obviously concerned that had there just been a slight adjustment to the wheel, this could have been a very different situation.
Okay. And what's the defense position?
Judge, as the officer noted in the interim, the DUI investigation is still pending before the court is a property offense, although we do acknowledge it's a relatively serious property offense with criminal damage of dollar values up to $50,000. Your Honor, before the court is not an aggravated assault with a deadly weapon dangerous instrument charge. So given the nature of the offense at this stage of the proceedings, we are asking you to consider releasing Ms. Marks to pretrial services.
All right. I will appoint the public defender. No return to the incident location, no contact with the victims, don't drive without a valid license, no alcohol or illegal drugs. And I'm going to release Ms. Marks to pretrial services given the lack of any kind of history. November 24th at 1:30 will be the preliminary.
Great.
What's your name, sir?
Angel Morales.
Got a warrant for you out of Maricopa County charging you with theft of means of transportation, 4 counts of burglary and 2 counts of attempt to commit burglary. And it appears that Mr. Morales has never been charged in this before. Is that?
Correct, Judge. Looks like a summons was mailed and Mr. Morales didn't have any notice, but he was never previously arrested on this case.
Okay, and it's from 2022. So, Mr. Morales, what I'm going to do is release you on your promise to appear, well, on your promise to report to Maricopa County Superior Court within 72 hours of release, okay? So you need to go in the next couple of days, call them or do whatever you need to do to contact them. Otherwise, the warrant will reissue. You understand?
Yes, ma'am.
All right, then I'm going to release you at this time since these are older. Okay. Right, I just made up a date on that. It wouldn't let me get out of it. What's your name? All right, Mr. Proudlock. Is this really an Aho? It's not, right? No, I'm looking at the wrong, it is, right. It's, my paperwork says Aho, that's why I was trying to figure out what, let me figure out something, hold on. All right, Mr. Proudlock, why is this say Aho? Really, but not through Aho. He's here. So we still have to give him an Aho date. Huh. All right, somehow we show him as being an Aho person, but I don't know why. Anyway, I'm gonna give him an Aho Justice Court date, counsel, and you all can figure it out. So, Mr. Proudlock, you are charged with possession of dangerous drugs, possession of drug paraphernalia, and possession of a narcotic drug. You may be eligible to participate in a, right? Let me look. I thought I saw that he was eligible. Yeah. You may be eligible to participate in a diversion program called STEPS. It requires you to participate in a plan specific to your needs for a short time. If you choose to participate and complete the program, these drug accusations, your arrest report will be permanently dismissed without you ever being formally charged. Are you interested in learning more about the STEPS program?
Yeah, ma'am.
However, counsel, I'm thinking. What? I think I'm gonna do our date. He's here, so, all right. Which is the 12th, same date. Well, it's 1:30. So, however, counsel, I'm thinking about holding Mr. Proudlock, one, because I'm gonna hold him on my cases. And two, he's got a really high risk assessment. So did you want to be heard before I make that final decision?
Certainly, Judge. I was actually going to challenge probable cause as to the dangerous drug count. What I see on the interim complaint is just allegations that he was in possession of heroin and some fentanyl, which are both narcotics, and I didn't see any dangerous drug. And it's an interesting interim, Judge, because typically the officer puts in the reason for the arrest, but
I know.
surprisingly, we don't have a reason.
Yeah. There was another one, there were like, stopped for some, and they left out why the person was stopped. I saw that too. So heroin, so you're saying heroin and fentanyl are both dangerous drugs? Is that what you're saying?
Narcotics.
Oh, they're both
Drugs.
narcotics. Oh, and me and the officer didn't even notice that. So does the state want to be heard on what I should?
Your Honor, we do have inconsistencies sometimes with police reports, and when the county attorney's office gets a hold of them, we amend the charges to the correct charge. I do believe there's enough information here to hold him on probable cause, given the paraphernalia, the possession of the heroin and the narcotic.
Okay. All right, so I guess I could say that if I don't find probable cause, then I would release him, but then he's going to be held on my TV court case, counsel. So shall I just hold him anyway? But I'll hold him on a lesser bond because I do agree with you that it's kind of not the greatest probable cause statement.
Okay, Judge. Then I'd ask for $25 for time credit. I know that's a that's a lot to ask, but Mr. Proudlock is unable to afford any bond at this time. So
Okay. All right. I am going to appoint the public defender for Mr. Pradlock. No alcohol or illegal drugs. I'm going to hold him on a $500 bond because I agree with the probable cause assessment and release to pretrial if posted. And the preliminary or the stepped hearing will be November 12th at 9 o'clock. And the preliminary hearing will be November 12th at 1:30. Then Mr. Proudlock has a probation revocation out of city court, and the allegations are that you failed to complete your intake, you failed to complete domestic violence intake and treatment, failed to complete substance abuse and alcohol evaluation. So, and then you've got a criminal trespass, failure to appear, and a new drug paraphernalia and criminal trespass. So I am going to hold you on a $24.99 bond, appoint the city public defender, and your next court date will be November 19th at 1:30, and I'll enter denial of the allegations on the PTR. And that's it, sir.
But
What's your name, sir?
Oh, Chavez.
All right, so you are charged with aggravated driving under the influence, going the wrong way. And I don't see any criminal history. Does the state want to be heard on why they're asking for the $20,000?
Yes, Your Honor. Obviously, this is a serious offense in the fact that it puts the public at large in danger. He was driving the wrong way on the freeway. He had a 4 of 6 on the HGN and an open container of marijuana in his vehicle. So the state believes in order to protect the community, the state is asking for a bond.
Okay, so when I first read this defense, I thought maybe he was a student here, but it sounds like maybe he's just visiting here. And so would we be able to find him if he is released?
yes, Judge, can I just talk to him for just a moment? So that way, can. And Judge, if I understand correctly, the court is not inclined to grant permission to travel out of state at this stage.
Well, I don't think I would be. I would rather the next judge do that, but I'm not
Sure.
saying I'm not willing to release him, but I don't want to make that kind of decision for the just assigned judge. So,
Oh, okay, I understand. So Judge, Mr. Shivers is explaining to me that he will make some arrangements till he sees a Superior Court judge to get that travel permission. We are hoping that the court will release Mr. Shivers to pretrial services supervision due to a complete lack of history. And pretrial was able to talk to his mother, who lives in Texas. So he will abide by all court orders at this stage, which is why they're asking for release.
okay. All right. Well, given the lack of criminal history, I am going to appoint the public defender, order the defendant not to drive without a valid license, no alcohol or illegal drugs, and I will release him to pretrial services. But I am going to say don't leave the state, sir, until you get authorization from a judge this is going to be in front of. And the preliminary hearing will be November 24th at 1:30. And by the way, I grew up in Evanston. It's a great town. So, all right.
Make sure you do. See you, Russ.
What's
For
your
some
name?
reason, I thought it was California, Judge. I don't know why.
Oh. What's your name, sir?
Silvas.
All right, Mr. Silvas, you are charged with possession of a dangerous drug, 2 counts, possession of narcotic drug, possession of drug paraphernalia. And you may be eligible to participate in a diversion program called STEPS that requires you to participate in a plan specific to your needs for a short time. If you choose to participate and complete the program, these felony drug charges in your arrest report will be permanently dismissed without you ever being formally charged. Are you interested in getting released from custody? Well, I never say that part, but I'm going to release you anyway. And learning about the STEPS program at your next hearing? Okay. So I will appoint the public defender. Order you not to possess, consume any alcohol or illegal drugs, release you to pretrial services. The STEPS hearing will be November 12th at 9 o'clock. And then counsel, you want to waive time on the preliminary hearing?
Certainly, Judge, and I believe the 45 days puts us to December 17th.
That's what we calculated here too. So that's when the preliminary hearing will be, sir. So make sure you come to that first STEPS hearing, November 12th.
So
What's your name, ma'am?
Jillian Steventon.
You're charged with possession of a dangerous drug, possession of narcotic drug, possession of drug paraphernalia. You may be eligible to participate in a diversion program called STEPS that requires you to participate in a plan specific to your needs for a short time. If you choose to participate and complete the program, these felony drug charges in your arrest report will be permanently dismissed without you ever being formally charged. Are you interested in learning more about the STEPS program at your next hearing?
Yes, ma'am.
All right. Then I will appoint the public defender to represent you. I will order you not to possess any alcohol or illegal drugs, release you to pretrial services. The STEPS hearing will be November 12th at 9 o'clock. And then counsel, you want to waive time on this one also for the preliminary hearing?
certainly, Judge, and never mind, I'm not going to make a probable cause challenge.
Yeah, well, I'm releasing her, but I get it. I know, I thought of that too, but she's being released. That's the best I can do. So,
Yes.
all right. So December 17th at 1:30 will be the preliminary hearing. And that is it.
Thank you.
So